I'm Leslie Teague, and this is Ask CRA. I'm joined by Vance Piggott of the Chronic Law Firm in Sacramento and a valued CRA Legal Center partner. Today, we're going to continue our conversation on immigration. Vance, I understand there are differences between the federal immigration laws and then there's California labor laws. So as they apply to immigration, can you kind of help our members understand what these differences are and walk us through that?
Yeah, of course. So immigration law is set at the federal level. The state has no ability and no authority to come in and change or contradict that federal law in any way. Those laws would certainly be considered invalid. But where there is not a specific federal law that applies, California can come in and regulate and impose additional laws. So back in 2018, in response to kind of the initial focus on immigration law and additional enforcement and concerns about ICE raids, California legislature came in and said, well, we're going to provide what they call a California Immigrant Worker Protection Act that now puts in place some requirements that employers have to abide by in terms of how employers handle that, either an I-9 audit or an ICE raid. So specifically, what is required of employers there is, and in part one of this series, and we talked about the federal law, and everybody should go back and listen to that. It is good information to have. We talked about the requirements of the warrant and providing consent outside of that warrant. California law makes really clear that employers cannot provide voluntary consent for either entry into areas that are not permitted pursuant to the warrant, and also provide that employers cannot give additional documents to ICE or another agency during an ICE audit unless it is specifically covered by that warrant. So that idea of voluntary consent, like we talked about, employers should absolutely not do that, and it is prohibited under the California Immigrant Worker Protection Act.
All right. Are there any other things that you think our operators need to know that would be helpful to them during this, somewhat contentious or concerning time?
Yeah. So again, and we talked about it a little bit in episode 1, is you need to plan for these things. If ICE shows up unannounced, it is going to be scary and it's going to be chaotic, both for you and your employees. You need to have somebody put in place designated as a point of contact who understands both the rights of the employer and to some extent the rights of the employees, to make sure that you are walking this really narrow line like we talked about. Federal law is going to be pushing on, we want these documents, and ICE agents might be saying, no, you need to give us this, you need to give us that. Meanwhile, California law says you can't give them anything unless it's specifically in a warrant. You do really have a thin line that you have to walk to, one, comply with federal laws and the federal agents who are at your door, and make sure that you're not violating California law. So have a point of contact who's designated, who understands these things and has some type of a plan in place and how to handle it to avoid some of that chaos and potential liability that can come during an ICE audit.
Okay, great. Vance, how do immigration laws affect anti-discrimination laws?
Yeah. So under the immigration law, you fall under one of two categories. One, you are either authorized to work in the United States or you are not authorized to work in the United States. California law specifically says that if you're authorized to work in the United States, you need to be treated the same as every other individual who's authorized to work in the United States, regardless of why, whether you're a green card holder, citizen, naturalized citizen, born, whatever the case may be. There is, under California law specifically, protections for non-citizen employees, and you need to treat those non-citizen employees the exact same as you treat citizen employees. One way that this comes about is if you are checking an employee's or potential employees' documents for an I-9, as long as they meet the requirements and they provide you sufficient documentation to meet those I-9 requirements, you're not supposed to ask for different documents or ask for any additional information other than what's specifically required by that I-9. Otherwise, that could be seen as treating non-citizen employees differently from those citizen employees. So again, walking a really delicate line there in terms of federal law is going to require you to do all of these things, but you absolutely have some limitations there under California law as well.
All righty. So thank you for your time. You have more information on this topic on calres.org. I would encourage you to visit our site and find past webinars, white papers, and just all sorts of great resources. Thanks for your time, Vance.
Thank you, Leslie.